All right, hi, welcome back. Tony Steve Vonder, and welcome to another exciting video. So we are talking about NFT lawsuits. Guys, I told you these were coming. So here we have a powerhouse, Nike, upset about the use of NFTs by Stockx, an online sneaker and apparel seller, and also launching this NFT, these Vault NFTs that have pictures of Nike shoes, and Nike's not too happy about it. So let's take a look at this complaint. And again, at the outset, I'm just going to tell you, when you're buying NFTs, make sure you know what you're buying, that what rights you're getting, and make sure that the person that's selling you the rights affirm that they actually hold the rights. I mean, I think this is very important. You don't want to find yourself in a lawsuit over buying something and you don't really own it because it's an infringement on somebody else's copyrights or trademarks. So this is general allegations. Everybody's presumed innocent. That's how it goes. You know it. Here's the case number. I'm going to put it in the description box below if you want to take a look at the whole case. It's filed on February 3rd, 2022. One of 50 pages is what we call a whopper complaint. This is big. I'm not going to go over the whole thing. I'm going to try to skip to the important stuff. Complaint, jury trial requested. As always, request it or waive it. So let's take a quick look at the lawsuit. As I mentioned, lawsuit arises from defendant Stockx's unauthorized and infringing use of Nike's famous marks in connection with Stockx's entry into the non-fungible token, that's NFT, market. Non-fungible tokens, or NFTs, have quickly become pervasive in their use by brand owners seeking to enter the nascent marketplace of virtual or digital products connected to a token on the blockchain. So this stuff is on the blockchain, and it's all basically digital, okay? So NFTs are commonly understood to be blockchain-based virtual products. Some people call it digital collectibles. It can be collected, sold, and traded in the marketplace. They're an exciting way for brands to interact with their consumers in and out of the metaverse. And diverse commercial applications of NFTs have emerged throughout the past 2 years. And NBA's like killing it with their NFTs. So, and I think Nike got their own, I think they bought their own NFT studio. So they're in the market themselves. So, and of course they have a big popular brand. So we'll see how that works out. Back to the complaint. Far more than a fleeting trend, NFTs are part of the future of commerce. I believe that 100%. And I think that's going to be pretty clear, if not already clear to most. Unfortunately, novel product offerings, burgeoning technologies, and gold rush markets tend to create opportunities for third parties to capitalize on the goodwill of reputable brands and create confusion in the marketplace. That's your trademark issue. NFTs are, not surprisingly, no exception to the rule, and this new frontier has swiftly become a virtual playground for infringers to usurp the goodwill of some of the most famous trademarks in the world and use those trademarks without authorization to market their virtual products and generate ill-gotten gains. Don't you just love that phrase, ill-gotten gains? Enter defendant Stockx, the operator of an online resale platform for various brands of sneakers, apparel, luxury handbags, electronics, and other collectible goods that purports to provide authentication services to its customers. Stockx publicly touts the fact that Nike products drive more sales on its e-commerce platform than any other brand. That's not surprising. Nike's an awesome shoe company, and Stockx advertisements and social media accounts are teeming with images of Nike goods. Recognizing firsthand the immense value of Nike's brand, Stockx has chosen to compete in the NFT marketplace, not by taking the time to develop its own intellectual property rights, but rather by blatantly free riding, almost exclusively on the back of Nike's famous trademarks and associated goodwill. Specifically, and here's a look at some of the NFT, what they call the Vault NFTs that they sell, and they're tied into a digital product, and we'll talk about that here. Specifically, without Nike's authorization or approval, Stockx is minting, that's how you make an NFT, you mint it, minting NFTs that prominently use Nike's trademarks, marketing those NFTs using Nike's goodwill, and selling those NFTs at heavily inflated prices to unsuspecting consumers who believe or are likely to believe those investable digital assets, as Stockx calls them, are in fact authorized by Nike when they are not. Unlike its e-commerce business, which caters to buyers and sellers of goods originating from various companies, nearly all the NFTs minted by Stockx to date are Nike-branded NFTs, yet none of those NFTs originate from Nike. That's why you're going to see a false designation of origin claim, trademark infringement claim, unfair competition. Example, here it is. Like I said, so you have Stockx here. Here's the shoes. You have the trademarked swoosh symbols. These are trademarked, the swoosh. And I noticed on these here in very small print, at least I think I noticed right here was the word Nike. So it did, of course, they're just telling you what it is. But Vault NFT, you can see ERC, what's that? ERC 1055, I think it is. ERC 1055, that's Ethereum, or 1155. ERC, that's on the Ethereum blockchain, okay? Stock claims that it's 100% authentic. Nike-branded vault NFTs do no more than track ownership of a physical Nike product safely secured in its vault. But Stockx's vault NFTs are far more than just physical Nike shoes. And Stockx's claim that a vault NFT exclusively functions as a traceable digital receipt is belied by its own statements. Those statements reflect the fact that the Stockx's Nike-branded NFTs who purchasers can trade or collect and display their portfolio are new virtual products that Stockx has bundled with additional Stockx services and unspecified benefits, exclusive access to Stockx releases, promotions, events. Nike does not sell Stockx services or exclusive access to such benefits, yet Stockx's new virtual products have been created, marketed, offered for sale, sold by Stockx using Nike's trademarks without Nike's consent. That's really the crux of what's going on here, okay? And according to Stockx, it is just getting started. And they have a little link to one of their articles. Let's go with one more paragraph. I think you get the idea here. Just as troubling are other Stockx statements that appear to negate Stockx's primary claim that a vault NFT can be readily traded in for associated physical shoes stored in a Stockx facility. So they're saying you buy the NFT, you get the physical shoe. For example, while Stockx claims that vault NFT owners may redeem the NFT and take possession of the shoes for an additional fee, it also states that the redemption process is not currently available to NFT owners. Stockx also shockingly retains the right to unilaterally redeem a vault NFT for a so-called experiential component and take away the NFT, completely depriving the vault owner of possession of the shoes that are supposedly connected to the thing. So you can see Nike's upset about it here. It goes on, false association. They get all the allegations in there in their complaint. You can pause this if you want to look, but it's 50 pages, and I don't want to waste your time, and I don't want to waste my time. Interestingly, state of Nike is a Oregon corporation, Beaverton. I've been up there. And I actually work for a company that used to have Nike's account. I'm not going to go into anything further, but I used to live up in Lake Oswego, up right by Portland. And boy, was it beautiful back in the good old days. But they're in Oregon, and Stockx is in Michigan. So I don't know if jurisdiction's going to be challenged. But it's interesting to me that the case is in Southern District of New York. And just for your reference, case was filed by DLA Piper. I think that's Nike's main firm. But big law, big law firm. Personal jurisdiction claim, like I said, I don't know if that's going to be challenged, but you have a case in New York with a company, a plaintiff in Oregon and a defendant in Michigan. And, of course, they do business everywhere online. But we'll see how that goes. I'm not going to go into the blockchain. This will tell you more about the blockchain. But let's go down. Let's see if there's any more photo goodies. There it is. There's some of the trademarks. And you can see you get the Jumping Man trademark, the word mark for Jump Man, the word mark for Dunk. Boy, that's impressive. You got the Trademark on the word dunk. Incredible. Air Jordan, you all know those shoes. Another logo for Air Jordan. So these all can be, you can see the tremendous amount of assets that you can get with trademarks. These are all valuable assets in their trademark portfolio, and they're seeking to, protect these marks. You have a swoosh that's white, a white design. You have a black one. You have a swoosh with the Nike. And you have different categories. You may say, well, why is there two? They're in different categories. But anyway, and here's your registration number over here in case you're wondering. But anyway, that's kind of trademark law for you. There they are. Registration numbers. Let's see if we can get down to the causes of action real quick. You get the gist of this, I believe. And so Nike's not happy with their reselling. I believe Nike has their own NFTs, and they think consumers will be confused. So this will be an interesting case. Again, just more stuff on their thing. What do we have here? Nike Dunk Low being sold on the Stockx site. Here's something I'm going to talk about, this volatility. I'm going to talk about this in another video, but not right now. Make sure you bookmark and hit that notification button so you get these future videos. We're going to try to hit 50,000 subscribers this year, so we need your help, need your support, need your viewership. All right, so here it is as of February 2nd, 2022. The average price of the Vault NFT is $809, with the highest trading being $3,500. So these are, expensive, and I think Nike's position, this is my opinion, they're like, wow, you're trying to capitalize on our Nike, our trademark goods, and at very high prices, and we're going to be doing our own NFTs. So again, I know that StockX has stated they are going to vigorously defend. They disagree, so we'll see how it plays out. But I'm not going to go into all this. Let's see if we can get down. There's a lot of stuff about the shoes. Different articles from their site. Something from the NFT license that looks like they didn't like. Something, the right to unilaterally redeem or cancel or take away the NFT. For some reason, Nike's got an issue with that. If you want to read it, I'll put it down there. Here's the information if you want to pause what they mean with the experiential component. But let's go down. There's more of the shoes, different colors, different things. So I'm not going to go into all that. Let's see. Anything else good in here? Any other goodies? You see all the shoes. What do we have here? Let's see if there's anything else good. I like when a plaintiff attorney puts all the images and documents and things in here. Here's a tweet. Yeah, I'd feel safe assuming Nike gets a cut of the fees that StockX takes from each transaction. Let's see this tweet. Are these NFTs endorsed, approved by Nike / Adidas, etc.? How do they get the licensing to sell these NFTs with Nike branding? This is the real question right here, especially since Nike is jumping into this themselves. By StockX logic, I could do the exact same thing, just sell NFTs of stuff I've got in the collection. So you can see that kind of forms the basis. Just want to make sure I get it. The NFTs are backed by real sneakers, so you get the actual pair. The only difference between this and the old way is that Nike gets a small commission every time an NFT is purchased, right? So it's a way for Nike to get a piece of the huge pie of the resale market. I get the benefit for Nike, but I'm not able to see the benefit for us sneakerheads. Can someone help with that? So anyway, these are some of the things. You can cash out the NFT for the actual shoe, but I think it's just a stupid scam for Nike to make money. So I think Nike's point is that people are a little confused as to, is Nike trying to profit off this? So here you have the allegations, trademark infringement. As you'll see in trademark infringement, it's based on the likelihood of consumer confusion. Here it is. Likely to confuse, mislead, or deceive potential consumers, purchasers, and the general public as to the source, origin, sponsorship, or affiliation of the Vault NFTs with Nikes. That's the crux of a trademark claim. They're seeking their actual damages here, their profits. What else? They say when you have a trademark case, you have to say it's an exceptional case if you want to get your attorney fees. That's why I love copyright. It doesn't have to be exceptional case. False designation of origin. I talked about that. The unauthorized use of confusingly similar marks constitutes a false designation of origin. This is another very common claim you will see. I call it like ham and eggs, meat and potatoes. You kind of see them run together usually. By creating the false and misleading impression that the Stockx's Vault NFTs are produced by, authorized by, or otherwise associated with Nike. Again, suffered damages, actual damages. Again, exceptional case. Trademark dilution. Okay, this is where you have famous and distinctive marks. Again, a case. This is like your Coke, your Disney. I would say Nike probably qualifies for a famous mark. Everybody on the planet knows it, so they're probably going to qualify. So if you dilute, here you have, as a result of the duration, extent, and geographical reach of advertising, publicity, the amount and volume, geographical extent of Nike sales and tradings, their channels of trade, degree of recognition and registration, Nikes and marks have become distinctive and famous. It's your magic word. The wrongful use is likely to dilute the distinctive quality of Nike's marks. There you have it. It's a pretty simple allegation. Again, goes down to the same old remedies, goes down to exceptional case, I want attorney fees. I also noted, I'm not going to go into the remedies being sought, but I also noted that they were seeking punitive damages. I don't see this as a case, my personal opinion, I don't see it as a case for punitive damages. And then they strapped on, it looks like a state law claim for injury to business reputation under the New York law. Common law, fifth cause of action, common law, trademark infringement, unfair competition. Again, you will typically see unfair competition alleged along with these other causes of action. And where you have state law claims in federal court, that's supplemental jurisdiction. And, the court can decide whether it will allow those supplemental claims or not. Sometimes they do, sometimes they don't. So that's it. They're seeking an injunction. You can see here's how you kind of write an injunction. And for you new lawyers or lawyers out there, paralegals, you seek all this kind of stop them from manufacturing, minting, transporting, promoting, advertising, the whole gamut. Manufacturing, minting, transporting, publicizing, distributing NFTs, falsely implying endorsement, approval, sponsorship, engaging in other acts likely to dilute. So you have all these things that you would want them to stop. And now this one is interesting. In order that Stockx be required to deliver to Nike for destruction, and typically you could have goods destroyed, but NFTs are on the blockchain. Like this one is on Ethereum blockchain. There's lots of different blockchains, but this one's on Ethereum, and it's known. Blockchains are known to. It's like a ledger. It's like a public ledger, and they're known to be immutable. That means you can't change them. So I don't know that they can actually be destroyed. I don't believe they can, but maybe Nike wants to get them and disable any future trading of them, because there are, when you retrade these NFTs, one of the attractive features is that you can seek a royalty on future sales. That's why people love these NFTs, is you get a royalty on future sales. So maybe they just want to recapture them and disable. So I find that interesting. We'll see how that goes. But there you have it, folks. There's the complaint, DLA Piper. So there's a big lawsuit. As I said, 50 pages. It's a whopper. But we'll track this case. I hope you enjoyed this video. If you did, please give me a like, subscribe, give me some comments. I try to respond to well thought out intellectual comments. People that enjoy the law geeks. Will try to keep you up to date. Make sure to punch the like button, subscribe, hit that notification button for future videos. And that's it. I got to run. I hope it's been helpful, and we'll see where this goes. Again, these are allegations. Allegations are not evidence in a court of law, so all parties are presumed innocent until the case is proved. I suspect this will probably settle with some sort of deal worked out. Federal court cases can be very lengthy and expensive. That's just my prediction. Okay? Have a great day. Got to run. Enjoy your weekend. Bye now. AttorneySteve.com.